Cohabitation agreements in Florida, updated April 2022. People are getting married less and less often in Florida. That doesn't mean that people are not getting into relations where they rely on each other's mutual promises. However, a relationship can be whatever you want it to be under Florida law, and you can enforce the terms of that relationship in an oral or written cohabitation agreement. What is a cohabitation agreement in Florida? A cohabitation agreement is just like any other contract two people would enter into, asking for assurances from each other in the present and future. In the old days, people didn't want unmarried people contracting with each other, because that looked a lot like prostitution. Today, however, all contracts between unmarried adults in Florida will stand so long as they are not purely for sex. Even if the parties are having sex, of course they are, that doesn't turn a cohabitation agreement into avoidable prostitution/sugar baby contract. A written cohabitation contract will always contain non-sexual terms that will make the agreement valid. Written cohabitation agreements in Florida. Ideally, a contract should be in writing so the terms of the contract can be memorialized and interpreted. A mere piece of paper will not be enough to make a cohabitation contract enforceable. The contract and its signatures represent the offer, acceptance of offer, and the sufficient specifications, but there must be some kind of consideration in addition. Consideration is something of value given by both parties which induces them both to enter into the contract. Anything can be consideration. Mutual contribution to housing expenses. Cleaning the household. Care of one another. Again, the only thing that can't be consideration is sex. A written cohabitation agreement will contain the terms of their ongoing relationship, like who pays what percentage of the mortgage. More importantly, a written cohabitation agreement will contain the terms the parties agree to abide by during and after the parties' separation. Sample language of a cohabitation contract can look like this. Separation. In the event the parties separate or no longer wish to live together at Mediterra, the parties agree to the following. Either party may buy out the other party's interest in Mediterra at 50% of the equity in Mediterra. The equity in Mediterra shall be defined as the fair market value of the property at the time of their separation, less the balance of the mortgage, taxes, insurance, and/or other encumbrances on the property at the time of their separation. The parties agree that the fair market value shall be determined by their chosen realtor, Kristen Cavella. In the event that the parties cannot agree to who will buy out the property, then Mediterra shall be listed for sale. The listing agent or realtor shall be Kristen Cavella, who will determine the listing price at a fair market value for a quick sale. In the event of the sale of Mediterra or any replacement or subsequent property, the parties agree to split evenly the proceeds from the sale after satisfaction of the mortgage, taxes, insurance, necessary repairs for the sale, and/or other encumbrances on the property, as well as reasonable and customary closing costs. The parties agree that they will reside together until the property is sold. If for any reason either party vacates the property prior to the sale of the property, the parties agree that they shall nevertheless be each responsible for 50% of the monthly mortgage, taxes, and insurance until the property is sold. Additionally, a written cohabitation agreement can contain instructions if either party becomes incapacitated or dies. There is almost no limit on what can be contracted for between unmarried couples. One of the only limitation is that if the unmarried couple has children, they cannot contract for custody or child support in advance of their breakup. Oral cohabitation agreements in Florida. Most cohabitation agreements are actually oral contracts and not written contracts. So, if you're living with someone else, you are probably in a cohabitation agreement whether you know it or not. Again, what looks like a purely sexual relationship will not be enough to establish an oral cohabitation agreement. Other activities that look like cohabitation agreements or the result thereof will establish an oral cohabitation agreement. Determining the terms of an oral cohabitation agreement is very difficult. The parties will have to testify to what they agreed to orally and corroborate that agreement by proving they abided by the known terms. What a court cannot do is say, "This sounded an awful lot like a marriage, so I'm going to divide their stuff like they were married." A Florida court cannot order a divorce-like solution for a marriage-like relationship. For an unmarried couple, it will be very difficult to distinguish what was consideration and performance pursuant to the agreement and what was just a living expense they were going to incur anyways. Constructive trusts and cohabitation agreements in a Florida divorce. When there is no specific agreement, virtually all oral agreements, the court can make up an unwritten trust in which to hold the disputed property. This is called a constructive trust. The element of intent or agreement, either oral or written, to create the trust relationship is totally lacking. Establishing a constructive trust is not easy. A constructive trust looks more to fairness than the terms of the oral agreement, which would probably never be determined with any kind of specificity anyways. If you're living with someone and not married to them, you probably need a cohabitation agreement. A cohabitation agreement is a great way to ease your partner into a prenuptial agreement should things get even more serious. Contact my Naples, Florida Family Law office today to discuss writing up a cohabitation agreement.